Our guests in this studio include Cara Keys, Jefferson County Commissioner. Good morning to you.
Good morning, Rob.
Do you have a cold weather story growing up?
No, I don't, but I have a funny stink bug story.
Oh, what do you have?
Yeah. Well, once my room, when I was in high school, my room was really messy, shocker. And I wanted to crash in my sister's room who was in college. And there was apparently a crack in the window, and hundreds of stink bugs got into that room, and it was dark, so I didn't know. And so I lay into this bed, and I'm about to go to sleep, and I feel something at my feet. And so if you want to know what bug freaks me out, it's stink bugs. That completely horrified me. I could deal with a snake or spiders, but you give me a stink bug.
Did you get sprayed?
No, but I felt them all over me.
Because they were.
And they love to fly. When you have big hair, they love to fly into your hair. So I just feel like they've taunted me my whole life.
I don't think you need a crack anywhere for them to get in. I think they just
Get
sort
in.
of there.
Yeah, that was early on in the stink bug.
We're only like 4 years here, so that we built the house, and I swear to God, there must have been stink bug nests or something in the rafters or whatever.
Yeah.
It's finally settling down.
Yes.
So, but for the last few years, my office in particular, I actually I have a little gun that shoots salt to kill the stink bugs. It's pretty cool.
Second Amendment of it.
Good man.
Delegate
You're
Joe
a hero.
Delegate Joe Funkhouser is here as well. Joe?
Good morning. Winter is coming, and the stink bug 2.0 is now upon us of the next invasive species or hybrid with the spotted lanternfly.
Yeah.
My mother had a great trick for the stink bugs. You would take a 2-liter bottle, cut the top off, flip it inside out, and then they would crawl in there and they couldn't get out. So.
Oh, smart mom. Yeah. I was going to wonder if you had a story about stink bugs getting in your hair, Joe, but like me, that's not a problem.
Not anymore.
Let's talk about Jefferson County and the water bottling plant that was potentially going to be coming there. There's been some movement on that status. Cara, what's the latest?
Well, the latest is Judge Cohey backed the decision of the Planning Commission last Monday,
which was
that we had the right and the authority as a Planning Commission to reject a project. And so she has a written rejection that will be released at some point, but she backed what the Planning Commission did fully. So we have been, it's been about a year. So they initially, Sidewinder, the company, came to the Planning Commission in November of 2024. And I was a planning commissioner, I had just won my election, but I wasn't the county commission liaison at the time. I was just a planning commissioner. And they came then, and they came back at a concept plan in March of 25. And that was that infamous 8-hour-long meeting, which ended about 3 a.m. And we had about 123 public comments and about 500 people in that room that night. So generally opposing the project. And then, the Planning Commission unanimously voted to reject that decision, which was in March of 25. I led that motion. And then the lawsuit was filed. Sidewinder filed a lawsuit in an attempt to overturn the Planning Commission's decision. So, I'll Delegate Joe Funkhouser, there's some legislative session things that happened. But in July of this year, what was interesting about this case is we had an intervener file to intervene. So this was affected landowners near the proposed bottling project in Middleway. And near the industrial well in Jefferson County Foundation. They were granted the intervener status on the side of the Planning Commission. So locals were concerned about the health, safety, and welfare of their area, and so they wanted to intervene legally to support the Planning Commission's decision, and that was granted by Judge Cohey. And then November 5th, 2025, there were some negotiations for a settlement. And Sidewinder read in public session, their attorney, a list of proffers relating to the bottling project. And ultimately, the Planning Commission voted to deny that settlement agreement, and which prompted the court decision the following week. So this was right before we were going to court in November. And so that's kind of everything in a nutshell. But there was also a lot of legislative things that were done from both the from Delegate Funkhouser and other folks in Charleston. So.
Joe, you're also an attorney at law. Did your legal expertise become a part of this as well?
Not in that capacity. In my capacity as a Jefferson County citizen and resident, I want to commend my county commissioner for her courage and listening to the folks and their legitimate concerns with this particular project. And we have zoning in Jefferson County, unlike most of the counties in West Virginia. And there's things that you can do by right, and there's things that if you're trying to do something that doesn't comply with the zoning regulations, then you need to go to the Planning Commission and seek approval for them. And this whole thing wasn't on my radar until it was on the Planning Commission's agenda, and it got me looking at what the West Virginia law was, because I think we had sufficient laws for roads and the Department of Highways and things like that were part of this case. But in terms of the water, and like most states east of the Mississippi, we have a common law fair use doctrine. But when I was looking at other states, when you have large quantity users and water extractions, there are certain other regulations there to prevent the concern of the scale of draining the aquifer. And so there's a water monitoring requirement in many other states. It's to prevent this, regular citizens like the interveners from having to go to court, getting expert witnesses. Basically, it's an ounce of prevention. And so, like most of the surrounding states, I tried to introduce some common sense, reasonable regulations on this, as well as one on the zoning clarifying an ambiguity, because there was a provision inserted a few years ago regarding the natural use of one's land, and there was no precedent on that, and now there is. And so there's a lot of factors here, but I just want to commend my county commissioner, Cara, and the Planning Commission for their good faith efforts and doing their job. And also, back at the legislature, Senator Barrett, Senator Rucker also had introduced similar regulations or law to affect the DEP to control the situation, so that we can address the legitimate concerns of the scale of the water usage.
Is this your delegate district, this plant, Joe?
It is indeed, yes.
Okay, very good. Mr. Gilstrap.
So can you review some of the proffers that were offered and rejected through the settlement? Because it was not a unanimous vote by the commission.
It was not. There was generally, I don't have the proffers written out in front of me, but generally there was going to be well monitoring and provisions around some of the concerns. They were going to have monitoring around the former toxic plume that was below. So the case is a little bit complex, because you have a property that is zoned industrial commercial, which is where they would have the building, and then they would be piping water from about a mile away from rural zoned parcels on the other side of historic Middleway. And so there was a lot of concern over traffic, and so as an example, one of my concerns was the amount of trucks going by during school hours, during bus pickups, and just the safety of kids with all this increased traffic. So they did, proffer some things about times of day that they would be routing, decreasing, I think by 15, the amount of trucks per day. I think it went down to 145. Some well monitoring. It didn't, and one of the things that it kind of said. Clearly, it was the last provision, is that we had to kind of rubber stamp and say that we were wrong. And I think Planning Commissioner Donnie Fisher said, I can't do that because I don't agree that this project was correct and was permissible. And so I felt that the proffers were not in the community's benefit, and the community cared. I was elected to represent my constituents, and I felt like we did not get enough out of this deal to warrant settling.
So does the court decision put a stake through its heart? I mean, it's done and over, or
they could appeal. But one of the, I don't have any privy information like the Planning Commission does and their in-house counsel and all that. But I did read the briefs, and so from my layman's attorney's cap, one of the arguments that Sidewinder had made was because the Planning Commission's employee accepted their application and said your paperwork is in order, that somehow was an approval of their proposed project, and that would kind of make the purpose of the Planning Commission obsolete. Why would the Planning Commission even need to meet
Right.
To approve or deny and have an 8-hour plus long hearing to weigh the concept plan and so on and so forth. Mm-hmm. So I don't see any reason why. I haven't read the judge's order, but I've done a little bit of research, and I don't see why the Judge Cohey's order would not be upheld on appeal if they choose to go that way. One other thing that
Joe, before you go any further on that, would the appeal go to the ICA or straight to the state Supreme Court?
Intermediate Court of Appeals for civil matters first. Right. The one thing that's not really mentioned is they have the ability, the applicant, they do have certain rights with that property, their property rights that's zoned for an industrial usage, but they could have applied last year, they could apply tomorrow for a concept amendment or a conditional use permit, right?
Right. So one of the contention spots for me was that I'm a land use nerd, so I'm a commercial appraiser, and so whenever I do a report, I clearly define zoning, and I always look up, and so that's part of my profession. And so one of the
text a minute, I'm misstated.
Yeah. So there's a list of permitted uses that clearly define what can be done when you have a zoning of a particular property. And in this case, it's industrial commercial is where the buildings are, the proposed buildings we're resting on. Those parcels are industrial commercial. And one of the problems I had with the project is commercial water extraction or water extraction at all. If you're using it for your business as an accessory use, I think one of the things I said, it's like an appraiser coming in and having a toilet but no pipes. So what's the point? So for me, we did not have even a use listed in our zoning in our table of permitted uses. The closest thing we had was mineral extraction, and you would see on all of our zones, almost all of them are explicitly not permitted unless it's a conditional use. So for water extraction, commercial water extraction, we would want to have due process, and if we wanted to consider adding that as a permitted use or a conditional use, so they could either do a text amendment to allow that to be added to a specific zoning ordinance, or they could ask for some type of conditional use. We don't even have it listed, so I think a text amendment would be required either way. But that wasn't there, and so it's trying to put a square peg through a round hole. It just wasn't there, and so that was one of the many problems with the project. And one of the things that Judge Cohey ruled, I was in court last Monday, and one of the things she talked about too is, they were putting wells in rural parcels on the other side of Historic Middleway and then piping it through Historic Middleway to the facility. And one of the contentions is the potential destruction of the Historic Middleway, which is something that is a level of protection within our zoning ordinance, and there's legitimacy with, as an example, Bridget Cohey, the judge said, is that there is a Civil War burial grounds right next to the road that they were hoping to pipe this water, and so to intercede in that area would be a huge concern. And so,
Could you talk about also in the zoning ordinance? There's no any mineral extraction is not allowed, right? Any,
Right.
and that, I think part of the reason is because we have karst topography and hydrogeology, which is very sensitive to the mineral extraction.
And the karst, according to Bill Stubblefield, who is a geologist by education, was a concern in regards to that toxic plume as well. And I think many of the citizens objected because of the reasons of fearing their water supply would be tainted by that toxic plume left behind from when, I guess, 3M was there. Is that also a part of this?
oh yeah, there's a huge parts of this that are both scientific in nature and then the water. I mean, this was, in my opinion, a bipartisan concern in Jefferson County. This is not here's Democrats coming in and saying don't put anything basic here. This was, you had farmers crying about their farm potentially being destroyed. You had folks that never got involved getting involved. You had an outpouring of opposition, and so there's legitimacy to the TCE, the chemicals that were by 3M. And there's several hydrologists that were looking into this, people who were conservative, any political status were concerned. And a few of them actually came to the March 2025 meeting and explained their position and their background as evidence.
One of the things I found it amusing in a not terribly funny way about all this. My background is hazmat and haz waste and that sort of thing, that they're going to put in monitoring wells to tell you when your water is poisoned. It doesn't do anything to prevent the poisoning. It's just to give you a heads up if something bad has happened and your well is poisoned.
And you know this probably with karst topography. They did these, and I learned this. Obviously, this is not my area of expertise, but if they did a dye test, a hydrologist told me they would put like a certain coloring in your well or into a water source and see how quickly it would spread. And when you have karst topography, it's like highway channels below our ground, and so you could have, so they might be able to see that it's there and that it's spreading, but it could spread within 5 days, 10 miles away, and kick 1,500 well. I mean, you have no idea what it could do and how quickly it could spread.
Also, how does it work in West Virginia? Under West Virginia law, do I own my property down to the core of the earth? Do I own what's under my property as well as what's on top of my property?
If you own it fee simple, you would, unless you've sold those rights.
So these pipelines that they're drilling from the mile long under Middleway, those are going through other people's properties that would then be condemned to allow under their proposal.
Well, that was part of the forced pooling fight too, if I remember that whole argument a couple of years ago.
Well, and you have the whole milkshake argument. I drink your milkshake sort of thing. So there's actually a law called it's in the DEP part of the code. It essentially requires reporting for large quantity users, which is defined as any user, farmers accepted, that use more than 300,000 gallons of water per year. And that in that portion of the code, it says the state of West Virginia actually owns all the water subsurface in the state, but it's more of just a reporting requirement for large quantity users. I think when you look at those annual reports that the DEP does, I think the state of West Virginia uses almost 1 trillion gallons of water a year, and I guess the other factor here that I think we need to consider is there's other. This particular project, it's going through its course. They have options going forward. But we're also looking at the future of Jefferson County. We're growing population. We want to. I commend the county commission for reinstituting the Water Advisory Board, because there's just a lot of unknowns there, and that's part of what, if they applied for the text amendment, they could have worked through some of these unknowns and maybe gotten to figure a lot of these things out. And I was actually pleasantly surprised that when these proffers were made, when I was listening to the meeting, I was like, hey, this is a lot of what we were trying to do at the legislature in these bills, which they were lobbying against.
They had a local lobbying firm fighting when you guys were trying to pass some just common sense legislation.
No, they were trying to protect their rights, and I don't fault them there. But
hey, we've got a minute and a half left. If I can summarize this, tell me if I'm right or wrong here. Sidewinder, or whatever the company is actually called, still owns the property. Mm-hmm. They could apply for a different use business on that property, but for now, the bottling plant is dead based on the current ruling, but they can appeal to the Intermediate Court of Appeals. How long do they have to make that decision to appeal, Cara or Joe?
I would have to double check, but I think it's 30 or 60 days to file the appeal, and then they can perfect it at some point shortly thereafter.
It was 30 days in the initial reporting of it.
Okay.
The media reporting.
If they win their appeal, would the Jefferson County Planning Committee take this to the state Supreme Court?
I'm not sure. I don't want to speak for our lawyers or our planning commission. We haven't discussed that. And I did want to give a little shout out. We have a new thing on the county commission.
30 seconds.
Yeah, we are starting these town halls before our county commission meeting. And so this Thursday at 5:30 p.m., we're going to be talking about balanced growth. So some of these text amendments that we have coming in, as an example, we have this new zone called residential commercial, where we're going to require that 25% of the use is used for commercial as a way to curb some of this residential that we have blowing up in our county and ensuring that we have businesses growing.
Cara and Joe, thank you so much for coming in. We appreciate the information.
Thank you.